The first case to come before us this morning is Scott Schrader et al. Versus the Board of Trustees of Penfield Township et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. I note in this matter we have a cross appeal. That means the appellant, cross appellee, will have 15 minutes to argue and may reserve up to 5 minutes for rebuttal. If you are the appellee cross appellant, you will have your 15 minutes all at the one time. If you are the appellant, cross appellee, and wish to reserve time for rebuttal, please let me know when you get started. I'm keeping the clock and can keep you apprised of the passage of time. Please do not use the names of any victims or minors in your oral argument. I don't think it's necessarily an issue in this case, but we are live streaming this argument and it will be posted on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
May it please the court, Thomas White on behalf of appellants and cross appellees Scott and Sharon Schrader, and I'd like to reserve 3 minutes for rebuttal. Thank you. Your Honors, we start our argument this morning with where we normally would conclude, and that's our request for relief. We are simply asking that the court reverse and remand to the trial court for briefing and hearing consistent with the law. As the court is aware, at issue is a decision by a Township Board of Zoning Appeals to grant conditional use and area variances for the erection of a cell phone tower just across the road from my client's residence. This despite the fact that there is another phone tower on the other side of my client's property. Now, how did the trial court err? We submit that the trial court erred by failing to allow both parties to submit briefs, affidavits, and other pleadings in a zoning appeal and did not conduct a hearing as required by law. The record in the case reflects on April 8, 2021, the trial court formed up the parties in this case by denying the township's motion to dismiss the zoning inspector and denying the township's motion to join other parties. On April 9, 2021, only 1 day later, the trial court issued its decision affirming the township. Now, a major point of this appeal is that it is fundamentally unfair for a court to determine who the parties are in a case on one day and on the next decide the case. We cite the J.P. Morgan Chase versus Bergen case on page 9 of our brief, and which stands for the fact that the parties must be given a reasonable opportunity to respond to a trial court's ruling on preliminary motions before making a final decision. Now, what should the trial court have done? After the parties to the case were determined, the court should have followed the law and proceeded as in the trial of a civil action. That's right from Revised Code 2506.03a. If the trial court would have treated this case as a trial in a civil action, appellants would have argued, among other points, that a hearing was necessary as they were not afforded the right of cross-examination at the township hearing. And that's from Revised Code 2506.03a2c. At the court hearing, any party may call as if on cross-examination any witness who previously gave testimony in opposition to that party, and these points would have all been raised if appellants would have been provided the ability to brief the court on the applicable law after the parties to the case were formed up, but before a final decision was rendered. Now, following Revised Code 2506.03 would have permitted the trial court to fulfill its mandate to consider the whole record, including any new or additional evidence presented at hearing. And we cite the Rebuttal versus City of Avon Lake case on page 9 of our brief in support of that argument. Secondly, the trial court erred by requesting that the township supplement the transcript, but not conducting a hearing. If a trial court considers something other than the transcript filed by the township, it must conduct a hearing upon the transcript and additional evidence as may be introduced by any party. And that's found in Revised Code 2506.03b. In this case, on March 23, 2021, the court clearly requested that the township supplement the transcript originally submitted. The township complied on March 24, 2021 with additional information which the township indicated was relevant to the case. They called that their supplemental notice of filing of transcript. To allow the township a second bite at the apple while denying appellants the opportunity to make their own record in briefs and at a hearing is fundamentally unfair and contrary to law. When a trial court fails to hold a hearing after discovering sua sponte that the township's transcript is incomplete, the court cannot affirm the township's decision. The bottom line is here, Your Honors, that the court must provide an opportunity to be heard by both parties when the township's transcript is insufficient to rule on without briefs and without a hearing. And for those reasons, appellants respectfully request that this court reverse the trial court and remand for further proceedings pursuant to law to allow us an opportunity to brief the issues and to have a hearing as required. Thank you.
Counsel, I have a question. The cell tower is a conditionally permitted use, correct?
Yes, it is, Your Honor.
And it's my understanding from the briefs that the argument is that a conditionally permitted use is the same animal as a use variance.
Well, Your Honor, I would let opposing counsel get into the specifics of that, but when we say that it is a use variance, I believe that in essence they're two of the same kind of animal. So I would answer yes, Your Honor.
Thank you, counsel.
However, if I could, Your Honor, even if it is a conditional use, we would have argued, if given the opportunity to brief, that under Article 7.2 of the township's standards, both Articles 3 and 4 should have been allowed to be addressed. And that is whether the conditional use will be harmonious with an appropriate appearance with the intended or existing character of the properties. And number 4, will not be disturbing to existing or future neighboring uses. But we didn't get the chance to brief that.
So is that the test for conditional use, or is that the test for a use variance?
That is the test for conditional use. It's Article 7.2, conditionally permitted uses in the township regs, which was part of what the township supplemented separate from the original transcript.
Does the panel have any additional questions?
Was there a request for a hearing by Mr. Schrader?
Yes, Your Honor. In our original notice of appeal, we requested both injunction and hearing.
What about an affidavit? Was an affidavit filed?
I don't
Isn't there
believe
language in 2506 that requires an affidavit to be filed as well?
if an affidavit is filed, Your Honor. I believe that that's discretionary, not mandatory.
Thank you.
Counsel, you will have a full 5 minutes for rebuttal should you wish to utilize that time.
Thank you, Your Honor.
Mr. Mangan? You are muted.
Oh, I'm sorry. There I am. Yes, Your Honor.
We can hear
I'm
you.
ready to go.
Mhm.
Okay,
Yes.
I have 15 minutes, correct?
That's correct.
Okay, I'll just quickly respond to a couple issues that Your Honor's brought up, which are important here. First of all, there is no such thing as a use variance and being the same as a conditional use permit. In the Penfield Township zoning resolution, they have under their uses, they have permitted uses, prohibited uses, conditionally permitted uses, area variance, and use variance. Conditionally permitted uses are permitted if conditions are followed generally and specifically, which were in this case. Area variances are permitted if they follow the practical difficulties test, which they did in this case. A use variance has a whole new test, a much tougher test. It has nothing to do with conditional uses or area variances. Also, as Judge Teodosio brought up, a big failure on the part of the appellants is they never required any type of a hearing per 2506 of 03 of the revised code. They have to have that in there in the record so the trial court knows, and then the trial court can decide based on the factors whether or not to have a hearing or not. Never requested, never in there. So the trial court had no jurisdiction over that particular issue. This is a township case, Penfield Township down in the southern part of the county, very rural area, lots of farms. Of course, there are homes there too, and has to do with the BZA, the Board of Zoning Appeals. The Wolves are property owners down there. They own a vacant lot upon which this cell tower is to be erected at some point, they hope. And they were an applicant. I mean, they filed to the BZA to have that conditionally permitted use granted. Also, GPD Group, the agent for AT&T, also filed an application for the same type of relief from the BZA. Now, understand, you probably do already, the revised code in the 519.211 states that telecommunication towers are exempt from zoning to start off, just like agriculture, just like other utilities, unless a township official or an adjacent property owner renders an objection, and the Schraders did in this case, and then that requires that a BZA hearing be held. A fair and thorough one was held in October of 2020. All information was brought in. All people spoke that wanted to speak, the Schraders at length. And afterwards, the Board of Zoning Appeals did determine, let's go back a little bit, the applicants requested a conditionally permitted use for the tower and also an area variance pertaining to the property because the setback line required 280 feet from where the tower would be to the back line, and the applicants only had 235. Know that the boundary line where this variance would go to is actually separating two properties owned by the Wolves. So even though a variance was required, it's really a technical variance, but it still is a variance. Another thing that is huge to this case, important to this case, is that the Schraders never have appealed the conditional use decision granted by the BZA. In their original notice of appeal, November 20th, 2020, in the trial court, on page 2-4, it states that the appellants are appealing the decision of the BZA as it relates to a variance grant, never about a conditional use. The trial court then, when it got its transcript, it went through the transcript and it saw that again, the Schraders never brought up conditionally permitted use to the Board of Zoning or to the trial court. The trial court so found, and I'd ask you to take a look if you already haven't already, is to the trial court's decision April 8th. I see it attached to Mr. White's brief, and inadvertently, I believe page 3 and 4 of that decision is missing, but the actual trial court's decision, which you have in the transcript and I have attached to my brief, states that there was no argument brought up about the conditional use permit, so we're just going to speak to the variance, and that's all the trial court did. It moved forward. The trial court is not required in any way by law, 2506, and the statutes that come out of that chapter, nor out of the township zoning resolution, to hold to request briefs. Nothing mentions that. Many times they do, but in this case, the trial court decided not to. It did not schedule a hearing because it was never requested. It had no jurisdiction to do so. the Attorney White does talk about supplemental document that I added. That was really not, that was error on my part to term that supplemental document being submitted to the court, because it really wasn't a supplemental document, because it was never an exhibit at the BZA. It has to be an exhibit there. We never use the Township zoning resolution sections as exhibits. We read it out, we let the people know the zoning resolution is out there, but we never do use that as an exhibit. It's not in the transcript. And at a status conference in the trial court, and kind of informally requested from me, could you send down the zoning resolutions that you guys relied upon in your decision, which are stated in our decision. And I said, well, I'll do that. I don't know if I should have said no or not. And I should have titled it something along the lines of submission of a document requested by the trial court. But Mr. White was present, no objection, no concern. In fact, he probably wanted it there to help his side. So that went down there for whatever use the trial court had for it. I felt I should send it down to him, but it is not exhibit. It was not a supplemental thing. There was nothing else to add. Mr. White never objected to anything along those lines. Okay, I'm looking at my time here.
You have about 7.5 minutes remaining.
Thank you, Your Honor.
What relevance do those documents have if there's no appeal of the conditional use?
Right. Yes. I sent it down there, and
So did the court even consider those documents? Yeah, the
I don't know.
resolution. I'm talking about obviously the resolution, the 7.2.
I don't have anything officially about that. He asked me just to give them to him. I did. And I sent a copy out to Mr. White, but again, irrelevancy due to no conditional use being objected to. And even in the appeal to the court, to the Court of Appeals, I find that Mr. White, on behalf of his clients, only spoke to, I think he only spoke to variance there also. So the trial court, anyways, the Board of Zoning Appeals deliberated, held, and came up with a decision that the conditional use permit request met all the specific conditions required by the zoning resolution and all the general conditions. It also found through the practical difficulties test that the area variance met all the conditions that were required and granted same. So here we are now really speaking only about an area variance and nothing else. I'm looking here. And as you can see, and I know you know this law, the law relating to a trial court, and I guess in a way a court of appeals also, as to whether or not a BZA's decision should be held valid. There's all kinds of law that I cite in my statute and use forever. It's presumed to be valid. The burden is on the Schraders. No substitution of judgment, etc. All kinds of things along those lines which show with the transcript that that was done. That was done by the Board of Zoning Appeals, and the trial court so found. Trial court looked at the transcripts and made the same decision. And I know the court is more has to look to just the law as opposed to other things here. And I think that everything is met by the BZA and by the trial court.
Counsel, I have a few questions regarding the cross appeal. And before we run out of time,
I was going to get to that. When do I get to that, Your Honor? If I got to that later.
You have about 4 minutes remaining for your your time on
cross
argument.
appeal? Oh, I didn't catch that. I'm sorry. I haven't done one of these for some time. I have 4 minutes for the cross appeal?
Yes, and I have some questions to get us started, if you don't mind.
Okay, I'll get on to that. I apologize.
That's okay. I note that it's that in the brief, it says that the zoning inspector, who the argument is should be a party to this appeal, or I'm sorry, should not be a party to this appeal. Is that correct? Am I getting the argument correct?
Yes,
Okay.
that's my argument.
Okay, it indicated the zoning inspector stayed the zoning permit. Is the argument that if he were not a party, he would not have done that?
If he was not a party, he wouldn't have done what, Your Honor?
Stayed the zoning permit?
No, he stayed that beforehand.
Okay.
Once
That have to do with the
appeal was
status?
filed, he stayed that. Pardon?
And was the reason for that his status as a party?
No, as a party, the status of a zoning inspector, just fulfilling his official duties, totally separate from the BZA and the BZA hearing. They are not they are not saying two components of the same machine, as Attorney White pointed out.
Okay, and I have a question about GPD. Though GPD has some contract rights, it doesn't have any real property rights in the property at issue, correct?
No, it was hired by AT&T to be its agent in working on the lease with the Wolves, and also moving forward. They showed up at the BZA hearing with GPD Group, 2 people, and it was their job then to be working for AT&T. We only worked with GPD Group for this entire thing.
Where at this point is the prejudice to GPD not being a party?
I don't know if there would really be any jeopardy other than what the relationship is with AT&T and how they're paid by AT&T.
Because the cross appeal asks this court to overturn the trial court's ruling to not to join GPD as a party. So I'm trying to find out why, if this court made any ruling whatsoever, it wouldn't be just an advisory opinion.
Well, before I get to that, let me just state that I've been on this issue for a lot of years. I've always wondered why an appellant who lost at the trial, lost all the way along, really has no interest other than it might bother them to have a telecommunication tower in their area, which is totally illegal to have it there, even though there's another one farther over. I always wonder why they can decide who are going to be the parties in an appeal to the trial court and an appeal to the Court of Appeals. Certainly, the GPD Group has an interest in this. This is what they do for a living, and they worked this out, and they brought in everything on behalf of their client. And also, the Wolves. I can't understand how in the world the losers all the way up here can have hearings in front of the Court of Appeals, in front of the trial court or whatever, and can speak and address their concerns, yet the actual property owners, or the biggest ones to lose here, cannot be a party. And this is like a case of first impression to me, Your Honors. I know Mr. White cited some case law that really had nothing to do with this case, as I understand. I say that respectfully to him because I've worked with him, but it had nothing to do with it. I think this is a case of a first impression, and I'm asking this court to seriously consider, before an appellate decides who's going to be the parties, whether or not property owners who have the most to lose from this cannot be involved in the appeal process going forward. It's absurd. It makes no sense. It's unjust. It's everything else. Now back to GPD group, I think they're losing, they do have an interest in this. They have a property interest in it. Well, I'm thinking the GPD group, they might have signed off on the lease with the Wolves. I
And
think that was
counsel,
so.
thank you. You have answered my questions, and we have also gone a little over time, but I wanted to ask the other panelists if they had any questions before we move on to Mr. White's rebuttal. Seeing none. Thank you very much, Mr. Mangan.
You're welcome, Your Honor.
Mr. White, you have 5 minutes remaining.
Thank you, Your Honor. First, in response to Mr. Mangan's argument, we have a little bit of a sauce for the goose as a sauce for the gander. Yes, our notice of appeal did mention the variance. However, the order appealed from, which is attached to the notice of appeal, clearly states that's in re Penfield Township Board of Zoning Appeals decision on conditional use permit. So it's very clear to the parties and to any court what was being appealed here. Second, I want to make sure that we're clear that regardless of the content, when the court sua sponte asks the township to supplement the record, to supplement the transcript, and the township does that with its supplemental notice of filing township, then our reading of the statute is that requires a hearing. And I just wanted to make sure that I was clear on that. With regard to the cross appeal, I can kind of state our position very succinctly. First, as Mr. Mangan indicated, the zoning inspector stayed his issuance of the permit, but that is not in the record. The zoning inspector is a necessary party as he is the officer charged with issuing permits and variances pursuant to the decisions of the boarding zone of appeals. And while the issuance of permits and variances could be argued as a largely ministerial act, it is still separate from the acts of the Board of Zoning Appeals, and thus the inspector is a necessary party. In addition, dealing with the issue of whether the applicant for a cell tower permit and variance not being necessary parties, first, I won't engage in the diatribe of whether this is a matter of first impression, because I don't think the court has to go that far. I think that the court needs to look at what relief we were requesting in the trial court, which was sitting as an appellate court. We're not seeking the final reversal of the township's decision. We're not depriving a neighboring property owner of the right to use their property. We're not depriving AT&T or GPD or anybody else. All we're asking is that the court reverse and remand for a hearing in front of the Board of Zoning Appeals that conforms with the law. Ergo, there is no fundamental right of the neighboring property owner or GPD or AT&T or anybody else that is at issue here. We're asking for a remand and a new hearing that is pursuant to law. Therefore, the cross appellees respectfully request that the court affirm the decisions of the trial court in denying the township's motion to dismiss the zoning inspector and to add applicants as parties to the appeal. Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Supreme Court website. Our next video oral argument is Tuesday, November 16th. Gentlemen, have a great day. And
thank you very much, Your Honors. Thank you.
Yeah.